Hi, this is Kristen Carroll from the NGO Learning Centre. In August 2014, the Department of Family and Community Services conducted an NGO Legal Practice Forum. This seminar provided an opportunity for NGOs to obtain information regarding the care jurisdiction of the Children's Court of New South Wales. The President of the New South Wales Children's Court, Judge Johnston, and Robert McLaughlin, Solicitor, Advocacy and Children's Law Specialist, were the keynote speakers. The NGO team is pleased to be able to provide you with a copy of all the resources and links that were recommended during the forum, including the presentation papers prepared by Judge Johnston and Robert McLaughlin. For those of you who are unable to attend the seminar or tune in via the webinar, we are pleased to share with you this interview with Judge Johnston, where he not only reiterates the key messages from the forum, but also addresses questions brought up by participants on the day. The interview has been created as a series of 8 short podcasts. The first podcast in the series will examine the key concepts of the Care Act. But let's start off by hearing why Judge Johnston decided to become a judge in the Children's Court.
Well, actually, I never applied to become a judge of the Children's Court. Early in 2012, I was telephoned by the Attorney General, who asked me to take on the role of President of the Children's Court. At that time, I'd been a District Court judge for about 6 years. The Act stipulates that the President must be a District Court judge, and the previous President's term was about to expire. I said to the Attorney, "Why me? I haven't really done such a great job bringing up my own children." I had very little exposure to children's law, but did have some considerable experience in organisational management, and I decided that the role presented a fresh challenge and an opportunity to make a difference in an area of significant community need. The Children's Court of New South Wales now consists of the President, 13 specialist children's magistrates and 10 children's registrars. It sits permanently in 6 locations and conducts circuits on a regular basis to a number of country locations across New South Wales.
Who is ultimately responsible for decision making according to the Act?
The Children's Court is vested with its care jurisdiction by the Children and Young Persons Care and Protection Act 1998, what I refer to shortly as the Care Act, which governs all aspects of care and protection in New South Wales. The Care Act contains an inextricable mixture and combination of both judicial and administrative powers, duties and responsibilities. It is often difficult to precisely discern where the Department's powers and responsibilities begin and end, as opposed to those of the Court. In summary, however, the Act establishes a regime under which the primary and ultimate decision-making as to children rests with the Court.
Can you please explain the difference between the balance of probabilities and beyond reasonable doubt?
The standard of proof in care matters is on the balance of probabilities. This means that unlike in a criminal case, matters of disputed fact do not have to be proved beyond reasonable doubt. That means, for example, that allegations of harm or unacceptable risk of harm to children do not have to be proved to the high criminal standard. It is sufficient if the Children's Court considers that more probably than not what is alleged occurred. So it must be more than a possibility, but it does not have to be proved beyond reasonable doubt.
In the paper you've shared as a resource on our website, you discuss the concept of a realistic possibility of restoration. Can you share with our listeners what this means?
Yes, this is one of the key concepts in the Care Act. The phrase realistic possibility of restoration involves an important threshold construct which informs the permanency planning that is to be undertaken in respect of any child that has been removed or assumed into care. In many of the contested cases that come before the Children's Court, the central issue for determination is often whether there is a realistic possibility of restoration to the child to its parents. It is for the Secretary to make the initial assessment, but it is for the Court to decide whether to accept the Secretary's assessment. If the Court does not accept the assessment, it may direct the Secretary to prepare a different permanency plan. Regard must be had to 2 matters: A, the circumstances of the child; B, the evidence, if any, that the child's parents are likely to be able to satisfactorily address the issues that have led to the removal of the child from their care. There is no statutory definition of the phrase, and until recently there had been no judicial consideration of what it entailed. The leading Superior Court decision in respect of the phrase realistic possibility of restoration is called In the Matter of Campbell, a decision by Supreme Court Judge Justice Slattery. I have discussed the relevant principles in a number of judgments in the Children's Court, which are on the case law site for those that are interested in reading them, and they include Defax re Amanda and Tony and Defax re Oscar. The principles, however, may be summarised shortly in the following way. A possibility is something less than a probability, that is, something that is likely to happen. A possibility is something that may or may not happen. That said, it must be something that is not impossible. The concept of realistic possibility of restoration is not to be confused with the mere hope that a parent's situation may improve. The possibility must be realistic, that is, it must be real or practical. The possibility must not be fanciful, sentimental or idealistic, or based upon, quote, unlikely hopes for the future, close quote. It needs to be sensible and commonsensical. It is at the time of the determination that the court must make the assessment. It must be a realistic possibility at that time, not merely a future possibility. It is, however, going too far to read into the expression a requirement that a parent must always at the time of the hearing have demonstrated participation in a program or programs with some significant, quote, runs on the board, close quote. There are two limbs to the requirement for assessing whether there is a realistic possibility of restoration. The first requires a consideration of the circumstances of the child. The second requires a consideration of whether the parents are likely to be able to satisfactorily address the issues that did lead to the removal of the child from their care. And finally, the determination must be taken in the context of the totality of the Care Act, in particular the objects set out in Section 8 and the other principles to be applied in its administration, including the notion of unacceptable risk of harm.
What are the key requirements in a permanency plan?
Well, permanency planning is about what we do for the child going forward. The court cannot make a final care order unless it has considered the Secretary's care plan and is expressly satisfied that the permanency planning has been appropriately and adequately addressed. Permanency planning just means the making of a plan that aims to provide a child with a stable, preferably permanent placement that offers long-term security and meets their needs. The permanency plan will generally consist of the care plan, together with any other material that may have been provided to the court, such as documents, undertakings, and other material. The plan must set out the proposed allocation of parental responsibility, the kind of placement proposed, and how it relates in general terms to the permanency planning, proposed arrangements for contact between the child and his or her parents, relatives, friends, and other relevant persons, and the services that need to be provided to the child or young person and the agency designated to supervise the placement in out-of-home care. If it is proposed that the child is to be placed in permanent out-of-home care, the child or young person is entitled to a safe, nurturing, stable and secure environment, unless it is contrary to his or her best interests and taking into account the wishes of the child. This will include the retention of relationships with people that are significant to the child, such as birth parents, adoptive parents, siblings, extended family, peers, family friends, and importantly, their community. Decisions concerning out-of-home care placement of children in need of care and protection are not decisions that the court takes lightly or easily. A risk assessment is required in accordance with the principle that the safety, welfare and well-being of the children are paramount. It is now well settled law that the proper test to be applied is that of unacceptable risk of harm to the child. The court is also guided by the theory of attachment when making decisions about the care and protection of children. It is cognizant of the critical importance of socialisation and the formation of secure attachments in infancy and early childhood. It is vital that the court avoids a situation where a child or young person is placed in a succession of different placements. The permanency plan need not provide details as to the exact placement, but it must provide sufficient detail to enable the court to have a reasonably clear understanding of what the plan is. There is some ongoing debate as to just what is meant by sufficient detail in the context of approval by the Court of Permanency Planning. Today is not the time or place to wrestle with that issue in any detail, but I can tell you that the Court is having ongoing discussions with the Director Legal Services of the Department with a view to formulating, if not a set of principles for a consistent approach, then at least some agreement as to typical scenarios that do arise in that context.
In your experience, what aspects of permanency planning could be improved?
Well, by and large, I think that the permanency planning that we see is very adequate. I have made my views known in relation to permanency planning in the cultural sense, particularly for Aboriginal children, and I think we'll deal with that later. But my main criticism of the permanency planning is not so much in relation to the substance of the planning, but into the formatting of the permanency plan itself. And that's another thing that I'll talk about later.
Could you please detail the options for parental responsibility?
In addition to setting out the kind of placement proposed, the permanency planning must set out the allocation of parental responsibility. This term means all the duties, powers, responsibilities and authority which by law parents have in relation to their children. Before the court can make final orders in relation to the allocation of parental responsibility, it must consider the care plan presented by the Secretary. The court is also required to give particular consideration to the principle of least intrusive intervention and must be satisfied that any other order would be insufficient to meet the needs of the child. The Children's Court may make a variety of orders, including the allocation of parental responsibility for specific aspects to one or other persons. Specific aspects of parental responsibility that might be separately or even jointly allocated are unlimited, but they do include residence, contact, education, religious upbringing and medical treatment. For example, the court can allocate complete responsibility to the minister or allocate only some aspects to the minister and other aspects to the parents or some other person. Or it might make orders for shared responsibility between the minister and someone else. Parental responsibility might be allocated to some other person, such as the permanent out-of-home carer. But if sole responsibility is allocated to the minister is required, so far as is reasonably practicable, to have regard to the views of the persons who have previously had parental responsibility, such as the birth parent.
That wraps up our introduction to the key concepts of the Care Act. I hope you'll stick with us for the next podcast in this series, where Judge Johnston provides us with detail about the structure and processes of the Children's Court.